If you're an NRI, you're living abroad, you have a dispute ongoing with your wife who is maybe living with you or maybe has gone back to India, a lot of people make this huge mistake. They consult lawyers in their own jurisdiction. They spend thousands of dollars or pounds or the local currency, and lawyers, under a misinformed apprehension, believe and truthfully tell their clients, because that's what they understand about laws all over the world, that if you file your divorce case in the US or in the UK or wherever else you are residing, when the wife goes to file her cases in India and we show that we have in time initiated divorce in this country, that the Indian courts will refuse jurisdiction. The lawyers are not wrong, because that is what actually happens in most other countries that I have discussed this situation with clients. However, in India, this unique distinction is there. Indian courts do not care what case has been filed by the husband either in India or abroad. The wife's cases will be entertained on their own merit. The husband says, I filed my divorce. 1 week later, my wife files her domestic violence petition, her maintenance case, her FIR for dowry harassment, criminal breach of trust, etc. in her city, which is perhaps 1,000 kilometers away from my residence. Why am I being made to suffer when I have clearly being subject to counter cases by the wife? The courts of law very happily, the police very happily tell the husbands and their family members, we don't care. File your reply. We will consider these things at a later point of time. Later when, my lord? Later when, Daroga Sahab? Perhaps about 5 to 10 years from the date that the wife has filed these cases, because obviously she has filed her cases. You will file your reply. In criminal cases, State of Haryana Bhajan Lal judgment, we cannot consider anything apart from the averments made by the complainant, in this case the wife, and we will not look at anything else. In the civil cases, which are the maintenance cases, the domestic violence petition for compensation, and anything else that the wife files, the courts of law say, how can we go into your proof, your evidences, the fact that you filed XYZ case somewhere else in this situation over here? And that is the reason why you spend thousands and thousands of dollars, pounds, or whatever, under this misguided apprehension that once we initiated cases here, then we will not face any false cases in India, and the Indian courts will say, we don't have jurisdiction now. That is not how it takes place in this country. And the biggest kicker of it all is that even if you are able to obtain what is called an ex parte, EXPARTE, ex parte divorce in your jurisdiction of residence, Indian courts do not consider it to be anything, because Indian courts say that if you've obtained divorce on grounds which are not available as grounds, or the process has not been followed, then we will not consider this to be a divorce. So you cannot marry again. If you do, you can face bigamy charges, and you anyways face all these cases here. Now, some occasions, maybe 5% or 10% of the people watching this, there is the inverse, which is that if you initiate cases in India against your spouse, be it the husband or the wife, then the American, British, Singapore, German, Australian courts will refuse to entertain any case filed by your spouse against you in those courts. So the opposite is true, but the proposition that once we initiate cases here in this country, Indian courts will not do anything is completely incorrect. Now, do with this information whatever you deem to be fit. My name is Amish.aggarwala. I'm an advocate on record at the Supreme Court of India. Thank you for watching.